The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have 3 cases that will be submitted this morning. Those cases are Susan Ackerman versus State of Iowa and others. Second case is State of Iowa versus Dustin Ortiz. And the final case is State of Iowa versus Thurno Yaya Diallo. That last case is now submitted to the court without oral argument, and will proceed to hear the arguments in the Ackerman matter. Mr. Thompson.
Thank you, Chief Justice. Good morning. May it please the court, counsel. Nearly 30 years ago, this court adopted a tort remedy for wrongful discharge in violation of public policy as a narrow exception to the at-will employment doctrine. Since then, this court has repeatedly and consistently emphasized that this public policy exception should be narrowly applied in the context of only clearly defined and well-recognized public policy, only to protect those with a compelling need for protection from wrongful discharge.
I don't know if that's right. The public policy discharge tort is designed to promote the public policy. And indeed, in, I think, the Conaway case, I'm sure you're familiar with it, and I want to invite you to engage in colloquy with me. Yeah. Well, if there's a public policy, a strong public policy, that should prevail even if there's a private agreement that might not include it or is to the contrary. Why should we have, in one setting, the public policy tort does apply in an at-will situation, and then in a setting where there's a private negotiation, it doesn't apply? We end up with a quilt-like system of public policy torts.
Well, I mean, I think that what's helpful here, in the Conaway case, is something we need to talk about, and I'll be prepared to address it, but one of the things that I think is really helpful, and if you look at the district court opinion in particular and the plaintiff's briefing as well, is kind of ignoring the underlying case, which is Springer. And I think, Your Honor, in part, an answer to your question is going back to Springer. And if you look at Springer and what Springer did and what Springer said, it was a very specific balancing decision that the court made. If you look at footnote 1 in particular, I mean, footnote 1 talks about the fact that if there's a contract, that there would be other remedies available, but
really,
specific.
But let's just take Springer, or workers' comp is a good example. I mean, that's a relatively uncontroversial public policy. You fire somebody for applying for workers' comp benefits. I think 48 states have it or whatever, or a large number of states have it. The suggestion, I think, in your position, I want you to obviously clarify it, is that if there's a collective bargaining agreement, the employer can fire you for seeking workers' comp benefits, and there'd be no public policy tort for that. Can that be?
Well, I think the answer is I don't agree with the premise of the question. In other words, the proper cause standard prevents an employer for firing somebody for an improper cause. In other words,
but what if I'm negotiating a free negotiation? I even put a provision in my contract that says there's no public policy tort claims. I mean, I can fire you. You agree that I can fire you if you file a workers' comp claim.
well, I think the difference, Your Honor, is this, and I think if you go back to Springer and in particular look at Justice Cady's decision in Harvey, I mean, this is a implied, essentially, contract. If you look at Springer in the context of an at-will employment, the court decided that there were public policies that needed to be protected and enforced, and that in the absence of a contractual relationship, that the court would imply a contract that created this way to create a tortious interference claim, which is essentially what this is.
In other areas of the law, though, we allow both for tort actions and contract actions. personal injury cases, a breach of contract, which would be a warranty case, versus a tort for strict liability maybe, or products liability. And the reason we do that is because the damages are different and the remedies are different. And why should the area of employment law be any different than any other area of tort law where we allow both to be brought and the damages are different and the proof is different?
Well, there's two components, I think, to the answer to that. First of all, we're talking about a situation that has historically predominantly been either at will or governed by contract. And if you look at the Springer case, Justice Cady's decision in Harvey, particularly footnote 4, that talks about the importance of not undermining the fundamental expectations of the contracting parties and how this is
But the same thing happens in a tort case. I enter a contract with you that I'm going to provide you a certain product, and I have certain expectations of the product, and you signed for certain expectations of the product, but outside of that area, I'm still allowed to bring my tort case. I mean, the same argument can be made in the tort area about expectations.
But I think here it protects different things. In other words, I think that, again, in Harvey, the court talked about it's not the adequacy of the remedy, it's the fact that the parties have bargained for a remedy at all.
Well,
And-
that's not quite right. If, Harvey establishes, I think, a two-part test. The first part of the discussion in Harvey talks about the distinction between independent contractors and employees.
True.
And that distinction's been recognized in the law as a general proposition. An independent contractor maybe can walk away from the relationships more easily than an employee. It then goes on to the second step, which is analysis of the public policy. And interestingly enough, the whistleblower statute that was supposedly the source of public policy talks about a facility shall not retaliate against an employee. So the language of the statute only protected an employee. And then you close, the opinion closed, we fail to discern any clear public policy that prohibits the business, et cetera. So it seems to me the Harvey case was a two-pronged test. First, I think it's fair to say that independent contractors might have less protection, perhaps. But then it goes on to analyze the public policy, and the statute was a narrow statute, and therefore the plaintiff failed. Am I missing the case?
Well, I think there's maybe not a case, but there's a couple of steps I think you skipped, because I think that footnote 4, I'm sorry, expressly says, first of all, the availability of the contract remedies is all that is required, not a particular remedy that will actually provide relief. In other words, it doesn't focus on this question of adequacy. Now, to your second point, the discussion in Harvey about, well, we're going to go on and talk about whether there's a policy at all, that could have been another grounds, correct, substantively to reject the argument. So the court does that. In Hagen, if you look at the Hagen case, which we rely upon, the Eighth Circuit case, does a similar exercise and talks about policy. But here, and we kind of drive back to differences between the cases that plaintiff and that I think you're referring to, Your Honor, and this case alone, we do have, we're not contesting that the whistleblower concept is not something this court has recognized as worthy of protection. And so we're really talking about this concept that this is somebody who needs protection in such a compelling way that this court should imply a tort duty, okay? And
let me ask you this, Mr. Thompson. I mean, do we really need to adopt the broad proposition that whenever there's a contract between the parties, there's no wrongful discharge remedy, or can we rely on the fact that under 70A.28, this person has a remedy anyway?
Well, I think the answer is yes, but I think there's two pieces to this puzzle. Exactly, is that, we have this argument at the higher level of generality, but in this case, where they're asking you to extend this tort, we've got a public employee who's subject to a collective bargaining agreement with a just cause provision, which is governed by a statutory scheme, Chapter 20, that is different than this federal preemption argument that state law, state legislatures put in place, and on top of that, has a statutory remedy already in place, put in place by the legislature, that gives them a cause of action to protect the exact same conduct that's been complained of. In fact, it's pled in the complaint. So I think that, Your Honor, that you're right, that this is not the correct case to talk about these higher levels, because on the undisputed facts, in the face of the petition and the facts that plaintiffs have conceded, this is a plaintiff who is subject to a statutory scheme, has contract remedies, but also has a statutory remedy that addresses the exact same issue. There's a lot of discussion in plaintiffs' briefs and back and forth about the restatement and the different, categories of cases in the restatement. And one of the things about the restatement, that if you look at the different comments, and of course, sometimes, all they do is catalog cases, but comment G talks about different views on necessary versus not enough. But comment E we've talked about is cases where courts have said that if there's a statutory scheme, that's an exclusive remedy, or there's a civil service scheme, which is exactly what we have here. I mean, this court could rely upon the Van Ball case to say that there is an exclusive remedy here in the statute for what's complained of and sustain the motion to dismiss.
Oh,
but
but
here,
that's sure
Harvey also gives you that way to do that.
That's a comprehensive statutory scheme, the civil service scheme. Let me take you back to Conway, and I'm admittedly, this is, I'm reading you a section of it, and I want to give you a full opportunity to respond. I mean, among other things, the court states on page 800, the plaintiff's actions are recognizable state tort claims. They can be resolved without resorting to interpretation of the collective bargaining agreement, regardless of the discharge for just cause provision in the agreement. Now, I guess I read that on its face as saying, we don't have to look at the collective bargaining agreement. There's an independent state public policy toward.
Well, I think that under those facts may have been, it may have been true, because that's a different collective bargaining agreement and there's no statutory prohibition. But I think Conway is important because again, all Conway held was the court, had jurisdiction over these asserted claims. Both, the one thing that the Court of Appeals and the Eighth Circuit agreed on is that this court had never expressly addressed the issue and didn't read Conway for expressly expanding Springer. And the embedded problem with Conway, Your Honor, is, frankly, it's dicta. It doesn't direct the issue that we're here to talk about, and if it did, frankly, it's wrong. Because when the court also says, these are the same type of actions we recognized in Springer, all you have to do is read Springer to see that's not correct. And the underlying problem here is that the court decided that Lingle, a U.S. Supreme Court case, Lingle was based on Illinois law, and Illinois had already adopted the wrongful termination tort for collective bargaining agreements. I mean, so it bootstraps the problem, and then in dicta that gets carried forward for decades, and that this court's never really addressed until today, frankly.
It seemed to me Conway stood for the proposition that if an interpretation of the collective bargaining agreement was required, that would be preempted, and that was the attitude of the court, rightly or wrongly.
I agree, Your Honor. All I'm saying is that's a different question. That when a district court dismisses a case for lack of jurisdiction because of federal preemption, that's different than whether under Iowa law somebody can maintain a cause of action in the face of Chapter 20 or a statutory remedy. It's a different
Counsel,
question.
doesn't the statutory remedy control? We just had Godfrey, end of last term, recognize under certain circumstances an implied tort, Bivens-style tort, and yet those claims that fell under the Iowa Civil Rights Act were deemed governed exclusively by that act. Do we have the same situation here?
I think so. I mean, which is why this is exactly not the case to entertain this extension of what this court has always treated in a narrow way. And Justice Cady and Fitzgerald and in Harvey, you said that we should be cautious, that we're not trying to just impose general notions of fairness here, because we are disrupting the standard status of the law and implying these duties in order to protect a very narrow but very important category of things.
Your
And so
position,
again,
would your position be the same if it was a private employer and a private contract?
if it were
Similar-
a private employer with
Private
similar
empl-
provisions?
Similar provisions, you know.
Well, I mean, we wouldn't have, again, we wouldn't have the statutory preemption argument that 70A 28 gives us, or the kind of merit system argument that I've articulated. But under Harvey and under Hagan, that a private contract that has remedies for wrongful discharge, I think that is in the, if you accept Springer at its face, that's in the category of areas where this court has said we're not going to tread because the normal contract doctrines will deal with this, and we're not going to step into that gap.
Taking Justice Apple's hypothetical, what if you put in the private contract, if you file a workers' compensation claim, you're terminated? That's just cause.
I think it would be a void. I think again, you've got another concept in contract, that contracts that attempt to be in fact, facially in contravention of public policy or void as a matter of public policy. But again, we're not talking about those hypotheticals. We're talking about a public employee subject to a collective bargaining agreement with a just cause provision who is governed by a statutory scheme and has a statutory remedy. My time's up.
Mr. Thompson, thank you. Mr. Graham.
Chief Justice. Please, the court, counsel. I'd like to just address one issue that counsel raised, referring to this as a statutory preemption issue. Well, if it is a preemption issue, it is a direct corollary to Conaway, where that looked at the federal statute. Here we're looking at the state statute. And as in Conaway, here we believe the court should hold that the claim is not preempted by Chapter 20 or the remedy be exclusive under Chapter 70A, because similar in Conaway, the court does not have to look at the statutory scheme, which is not an exclusive civil service scheme, as we've seen in the Van Bale case, but allows for
We're talking about two different kinds of preemption. I mean, in Conway, what we're talking about is federal preemption of state law. What we're talking about here, I think what Mr. Thompson was using was a shorthand for the notion that there is no public policy tort when there's already a statutory remedy available for the same conduct.
I understand, Your Honor. I believe the comparison that I'm trying to make is that in both instances, you do not need to look to the collective bargaining agreement or the statute governing the collective bargaining agreement when analyzing whether the appellant here or an employee covered by a CBA has been terminated in violation of the wrongful, in violation of public policy. And I believe that was the point I was trying to make. And to be clear, we're here from our interlocutory appeal from a dismissal in which the district court granted the motion to dismiss, essentially stating that my client, the appellant, can't even assert the tort claim because she's covered by collective bargaining agreement.
Well, let me ask, let's pursue the line that Mr. Thompson was at least in part relying on, and that is that this case might be different if you had no remedy at all. And I might characterize his position, I hope I'm accurate, but I think what he's saying is, yeah, but here, no one's claiming that there's no remedy available, that under Chapter 70A, you do have a claim. It's just not a public policy tort claim. Number one, what's your position on the availability of a statutory remedy? And then number two, if the statutory remedy were the same as a public policy tort, you wouldn't have a complaint. So tell us why the statutory remedy is inadequate.
Well, the statutory remedy under 70A is inadequate. Well, just given that that does not, well, it's not adequate because it doesn't allow for the same remedies that the tort does. But I'd also argue that under 70A, there's some discussion about, well, isn't that enough? But 70A, under the Fitzgerald decision, it held that section articulates a public policy. It stated in that court decision that Fitzgerald, the wrongful discharge under the statute, that is a public policy upon which an employee can bring this very claim. So
Let me smoke you out a little more, maybe. Is this a punitive damage problem? Is that what we're talking about?
it certainly, well,
I mean, you might get punitive damages maybe under a public policy tort, and you can't under 70A.
It's emotional distress damages, which I believe are available, which are not under 70A, certainly. I believe I'd have some trouble with punitive damages against the particular defendants here.
You know, every statutory scheme is going to involve trade-offs. One advantage of that is you don't have to hire a lawyer for the 78.28 remedy, do you?
Well, I don't think you'd have to hire a lawyer to pursue this claim here. You can. I'm not quite sure I follow the...
Well, you can recover attorney fees under 70A, can't you?
I believe so, Your Honor.
And you wouldn't be able to recover attorney fees under a tort claim. Would that be right?
Not under, no, that's correct.
Generally, with a grievance process, often the union assists the employee. The employee doesn't need to hire an attorney. Wouldn't you agree with that? That's kind of the customary process?
Okay, yes, Your Honor, it is, but that also gets back to what a CBA protects, and that is what something the Court of Appeals discussed, relying on the Colon decision from the Kansas Supreme Court and those other Supreme Court cases in which the CBA, it needs to protect the collective good of the employees, not the individual employee. And perhaps, and I think is much more important here, is that a CBA, even one governed under Iowa statute, does not, and is not intended to protect Iowa public policy, which is what this tort is. It's designed to preserve public policy and protect the employees, all employees who have been terminated in violation of public policy.
Well, let's pursue the Godfrey analogy a little bit. And I understand Godfrey is a somewhat different case, but the majority, at least, found that there was not a constitutional right of action of money damages with respect to civil rights claims because of the civil rights remedy. I didn't agree with that because punitive damages aren't available. Was in the minority. If you read the Godfrey case, it seems to stand for the proposition that, well, the statutory remedy doesn't have to be exactly the same. In the Iowa civil rights context, you get attorney's fees. Don't ordinarily get that at common law. That's a plus for the statutory remedy. On the other hand, you don't get punitive damages. That's a minus for statutory remedy. But the kind of end gestalt coming out of Godfrey seems to be that if there's a substantially adequate statutory remedy, there's not going to be a independent, implied constitutional right of action. Now, you're not seeking a constitutional right of action, I know, but in essence, a public policy tort is kind of an implied cause of action. It's not expressly authorized by statute. So help me out with this. And I understand I was in the minority in Godfrey, but I think your task today is to convince the court that the Godfrey style thinking doesn't foreclose your claim.
Well, I don't believe it does, because if you look under the restatements that are cited to in the appellate court briefing and the cases from the Supreme Courts from other jurisdictions, we have two statutes. We have Chapter 20 and Chapter 70A. And Chapter 20, that just sets forth what the grievance process and what can now be bargained for under a CBA. And so with Chapter 20, really all you have is a CBA which provides for reinstatement and back pay. That's some damages and then the opportunity to go back to a job that you're fired from. So I think that's different from from Godfrey. And then with 70A, again, I'd have trouble reconciling the Fitzgerald case with the idea that 70A provides the exclusive remedy, given that in Fitzgerald, this court stated that no, that chapter it establishes a public policy which an employee can pursue under this tort. I hope that answers your question, Your Honor. And just to discuss one of the cases that the appellee is cited for the first time in their application for further review, the Van Vale case. This isn't, that dealt with Chapter 400, the Civil Service Statute. That is an exclusive and comprehensive civil service scheme, a statutory scheme. We don't have that here under Chapter 20. And so I think that's fairly easy to differentiate, and obviously the appellant is not a civil servant. She's a public employee. And turning to Conway, it obviously was a preemption case, but the real language there, it's key to note that case was decided just months after the tort was established by this court in Springer. And the court held that the public employee covered by CBA had a recognizable state tort claim, this claim. And again, there's a Court of Appeals decision, the McMichaels decision, and the federal court decision, the Beekman case, which supports that as well. And as far as the Hagan case goes from the 8th Circuit, the key language, well, two keys there. The employee there that was an individual contract, private employer, private employee. So the facts are different. And key to us is that, again, this was a motion to dismiss based on the pleadings, whereas in Hagan stated that the Iowa Supreme Court has consistently and carefully applied its wrongful discharge precedents to the specific facts of each case. So we believe that Hagan actually supports us in saying that we should have survived the motion to dismiss and been able to pursue our claim beyond the pleading stage.
Counsel, looking at Springer and his progeny, it seemed that our rationale was to level the playing field in cases where they didn't have a collective a contract remedy or a statutory remedy, and here we have both. Isn't the playing field already level enough?
Respectfully, Your Honor, I don't believe so. If the court were to affirm the district court's decision and state that as a matter of law, an employee covered by CBA cannot pursue this tort claim, then we'd have a situation in which the employer could bargain out a public policy claim.
What if we qualified the rule and said, where there is an adequate remedy provided in a CBA, that's the exclusive remedy?
Then, Your Honor, I still believe you need to reverse the district court's decision, because all the district court said was to the extent that the plaintiff has an adequate remedy under the CBA, then she cannot pursue her claim. I'm paraphrasing there, but to the extent that is the key language. So,
but as I guess I'm doubling back to where some of the other questioning, but if there is an adequate remedy, there might be some question of what's adequate. I understand you say punitive damages aren't available and emotional distress damages aren't available, but our rule could be that where there is no adequate remedy under the contract, then you do have the public policy tort.
and Your Honor, some of that was what the 8th Circuit was going for with Hagan in the private contract situation, and again, that very well may be how this court should rule, but that still requires reversal, still requires to affirm the appellate court decision.
So if the CBA had caps on damages and all this kind of stuff, that might be a different matter.
Correct, but the terms of the CBA here those aren't at issue. The court, as the Court of Appeals recognized, that district court didn't look to them, just said, okay, there's a CBA, regardless of the terms, no claim under the tort.
So you think we need to remand the district court? If we took on the notion that where there's a sufficient remedy in the CBA, there's no public policy tort. If that were the majority of the court, we'd have to remand for determination of what the remedies are under the CBA?
Yes, absolutely, Your Honor, because the terms were not at issue in the district court's ruling on motion to dismiss.
You raised a concern, employers could bargain away statutory rights, but could you respond to Mr. Thompson's point that any attempt to do so could be stricken down as void against public policy?
Well, it very well may, but also I still believe we have a situation which would allow that to happen, and that just the court shouldn't allow that opportunity to arise. And
Right, if it's void, is contrary to public policy, and there's no remedy in the contract, the argument might be that the public policy tort still exists. I will tell, quite frankly, as you can tell from my question, I'm more interested in this narrow issue than I am the broader proposition. The broader proposition that public policy torts don't generally apply to contractual arrangements, I think is a lot harder sell for Mr. Thompson, frankly. He probably gathered that from my questioning. But the narrower question as to adequacy of remedy, what you're really saying is, well, the court fashions its remedies for public policy torts, and those remedies can't be fussed with in a private agreement.
that's right, Your Honor, because then you have a situation, especially in the CBA context, in which if you state that a CBA employee just doesn't have access to this tort, if there's something allowed under the CBA, then those rights can get whittled down to a point where the at-will employee has more rights than the CBA employee, and then things just get turned on its head. So I see my time is up, Your Honors. Thank you very much.
Mr. Graham, thank you as well. Mr. Thompson.
Let me see if I can briefly address a couple of the questions. Justice Waterman, your question about the playing field, I think the answer is in Harvey, and where it talks about the fact that in Springer the source of this concern really wasn't clearly articulated, and that the other courts that the court was looking to talked about the inequality of bargaining position and the inability to obtain remedies and protection, and that's the reason that this court chose to imply essentially a contract, the tortious interference for which they found a cause of action.
Let me ask a question, probably what Justice Apple was doing. If you're right, and we limit it to if there's no public policy toward it, if there's an adequate remedy, alternate adequate remedy, don't we still have to remand it to the court to make that determination?
No, not in this case.
And why
Again,
not?
I mean, because I think 7828 matters here, and that the very first cause of action pled by the plaintiff.
Doesn't the court have to determine if 7828 is adequate?
I think as a matter of law, you can look at the statute, and you can look at what you did in Springer and decide that those kinds of nuances don't matter. You could argue that it's a better remedy, attorney's fees, that it can be brought both through the union process and as a private cause of action. I think the fact that in this case, again, we're not asking you don't have to decide the bigger issue, because on this case, on this CBA with this plaintiff, you've got a narrower question, which is an Iowa public employee covered by a collective bargaining agreement subject to Chapter 20 who has another statutory remedy, and that's enough for you to say, when we read this narrowly, for all of our cases, that we don't have a compelling need to step into a gap, because there is no gap here.
We have to find as a matter of law it's an adequate remedy.
I think you can. You've done it in other cases. I mean, that's what, you can look at it and decide whether punies makes all the difference in the world. At least in Godfrey, you decided that it didn't.
Quite narrowly, I might add, but.
I agree with that. But the Illinois court in Midget, when they recognized the tort as to collective bargaining agreements, focused on punitive damages. Coleman focused on this whole idea of collective good versus individual good. But the thing about all those cases, all those other state cases, and even the Court of Appeals decision, is that those were private collective bargaining agreements. Not a single case cited to you where a public employee that not only has a collective bargaining agreement, but a collective bargaining agreement subject to a statutory scheme. And in this case, in the state of Iowa, Chapter 20 is an articulation of public policy.
Do we have to buy into this Godfrey analogy? I dissented in Godfrey, but that was a constitutional claim. So the Constitution, if it required the result in Godfrey, trumps everything.
True.
What we're dealing with here is a common law claim where the premise of the common law claim is that you're carrying out the purpose of the legislature. And when the legislature has declared its purpose in a statute, what are we doing?
Right. And when I refer only to Godfrey in the context of this discussion about adequacy of remedies. So, no, I don't think this is a Godfrey issue. It doesn't have to be a Godfrey issue.
Well, do we have to analyze Section 78.28 to determine what damages are available before we can decide whether or not there's adequate remedies?
I don't think so. I mean, I think only if you go down Justice Apple's proposed route or Justice Wiggins' proposed route of wrestling with adequacy of remedies every time somebody files one of these claims. That's not what this court did in Springer. That's not what you said in Harvey, that the idea isn't to wrestle about adequacy. The question is there a path that provides a remedy for discharge or not? And that's the distinction, that's the status-based distinction that this court has historically made. And this is the wrong case, Your Honor, to decide to expand it, because on these facts, it makes no sense.
Wouldn't we always have to imply that remedies have to be adequate if they're going to have any force in our decisions on this issue? I mean, 78.28 talks of, it describes what the damages, recoverable damages are, and then they say, and other equitable relief as the court would allow, or something like that. Do we have to interpret that language?
I don't think adequacy is an appropriate analysis here. I think when you go to Springer, you look at what you said in Harvey, and the purpose of this implied tort isn't to make everybody exactly the same, but to assure that for certain public policy reasons, there is a path for somebody to contest a termination. So, I mean, this court has not previously decided this question, Your Honor. You should not extend the tort in this case on these facts. I think you have two paths. You have the Harvey path, which is there's a remedy, both contractual and statutory. I think Van Baal is a legitimate path too, that 70A28 is an exclusive remedy. But in any event, you should vacate the Court of Appeals decision and affirm the trial court. Thank you.
Thank you as well, Mr. Thompson. The case of Ackerman versus State of Iowa is now then submitted to the court.